Welcome. My name is Richard Weiner. I'm an attorney in the International Department here at Fredrikson and Byron. I'd like to welcome you to this Fredrikson International Seminar on Brexit, contingency planning for companies impacted by Brexit. We have a terrific program, fabulous panelists. I'm sure, right, guys? Well, only 2 out of 3, I guess. Where'd Nick go?
He's around somewhere.
Okay. Well, right now we have 2 out of 3 panelists. Hopefully the third will show up eventually. But before we start, I'd like to recognize 2 of our sponsors, Global Minnesota and the Minnesota Trade Office. So for starters, I'd like to ask Steve Riedel of the Minnesota Trade Office to come on up and say a few words.
Good morning, everyone. Thank you, Richard. Could I see a show of hands who has not heard of the Minnesota Trade Office before? You all have, every one of you. That's wonderful, so I won't bore you with the introduction today. So I'm really grateful that Fredrikson and Byron is helping us perform our mission of educating Minnesota companies on what's happening globally. That's what we do. We're the state's export promotion agency. I cover Western Europe for our office. I have colleagues who cover other regions of the world. I also cover environmental and energy industries. But I'd like to learn something about Brexit as well. It's something that comes up a lot in the news. It's something that comes up with a lot of our companies that we serve. And once the news was out that the Brits had voted in favor of leaving, the consulate in Chicago, our closest diplomatic neighbor, was very quick to say, we're still open for business, don't worry. We want to keep this relationship strong, and I'm sure we'll be hearing some messages about that today too. But we do want to know, what exactly does it mean? What does it mean to our company? So I'm looking forward to an education myself. So we're so grateful that law firms like Fredrikson and Byron offer events like this because, like I said, it really helps us with our mission. Britain is a crucial trading partner. And before I leave the podium, I just want to plant one seed. I was talking with a couple colleagues this morning about the fact that here in Minnesota, we've got chapters of national level chambers of commerce for France and for Sweden and for Finland. We don't yet have one for the UK, but I think that there may be room for one. And the state of Minnesota and our consulate here, our consular officer with Jan here in Minnesota, if there's a critical mass, if there's an interest in that subject, maybe we should talk about that and have a stronger presence connecting UK businesses and Minnesota businesses. So I will leave it at that, and I'm very much looking forward to learning about Brexit this week.
Thank you, Steve. Very nice. I agree. We got to do something about stronger commercial connections between Minnesota and the UK, no question. I'd also like to ask Tim Odegaard to come up and say a few words on behalf of Global Minnesota.
Good morning, everyone. I'm Tim Odegaard. I'm Program Director at Global Minnesota. We're a nonprofit, nonpartisan organization that connects, informs, and engages Minnesotans across a whole host of international issues. And we are really proud to partner with Fredrikson and Byron on numerous programs. They're one of the anchors of our corporate program. Pat Kelly, one of our board members, and we always enjoy the opportunity to co-sponsor or partner with you on different programs. In the past year, we've seen incredible interest in what's going on in the UK and the EU. Last November, the topic of our annual conference was the future of Europe, and our keynote speaker was David Rennie, the Washington bureau chief from The Economist magazine, talking about Brexit and beyond. And then just a couple of months ago, we partnered with the UK government office, Jan Bauer, and the Consulate General in Chicago to bring the new Consul General, John Seville, here to engage with the Minnesota business community on trade and investment issues. So certainly many questions. We're now less than a year out from the scheduled departure of the UK from the EU. So we thank Fredrikson and Byron, the international practice, and Walker Morris for sharing some information that businesses really need right now. So thanks.
Thank you, Tim. So without any further ado, let's meet our panelists. Our first panelist today is Dan O'Gorman. Dan is a partner in the M&A and Securities Group at Walker Morris Law Firm in the UK. Dan has been recognized as a leading UK practitioner for M&A transactions and IPOs and equity market capital transactions in both of the principal legal UK directories for the last 8 consecutive years. So he's a big shot. Dan has also been recognized this year, 2018, by the principal UK legal industry publication, The Lawyer, as one of the top 100 lawyers practicing in the UK today. Dan was chosen for his leading role as a UK M&A dealmaker and noted for his work over the last year on public M&A transactions. Dan received his Bachelor of Law degree from the University of Nottingham and attended law school at Nottingham Law School. Dan.
So, thank you, Rich, and thank you for that introduction. And it's a pleasure to be here in Minneapolis today to have the opportunity to talk to you about Brexit and some of the issues around Brexit. It's probably fair to say that we would rather have not been here talking about Brexit and talking about something else instead. And I'm probably not giving away too many secrets to say that of the panelists on the Walker-Morris team in the 2016 referendum, we were all in favour of remaining in the EU. And it's still a very emotional, divisive issue in the UK. If you voted to leave, you are probably now incredibly frustrated at the speed of the process towards leaving. You are incredibly frustrated when news breaks of possible compromises relating to the future relationship between the UK and the EU. The phrases going against the will of the people and going against the result of the vote are very common to hear from people who are in favour of leaving. On the other hand, if you were in favour of remaining, you are probably still slightly in denial about Brexit happening, and actually there's sort of maybe a lack of willingness to see some of the benefits and opportunities, certainly in the medium to longer term, that will come from Brexit. Benefits and opportunities for UK companies trading outside, benefits and opportunities for businesses trading into the UK. There's still a lot of emotion around, but we're at the stage now where you probably have to put that to one side and start to think about the practicalities, because Brexit is happening. It is complicated. There are many and varied permutations and possible outcomes. And it's happening, as was said, in less than a year, 29th of March, 2019. So we do need to get to grips with the practicalities of it, which is what we're going to try and touch on today. It's not an exact science, because I think there are probably a lot of people in this room who involved in negotiating and negotiations, and I think, as everybody will know, the first 90% of a negotiation is the easy bit, and the last 10% is the difficult bit, and that goes to the wire. And that's where we are in negotiations relating to what the future may look like at the minute. And I think you'll probably hear it more than once today, but the mantra from the EU is nothing is agreed until everything is agreed, which means sort of planning for exactly what might happen in a year, 2 years, 3 years is still quite difficult. We thought it was probably useful to just cover some of the jargon. So the single market is probably pretty self-explanatory, but it's worth remembering that there are 4 aspects to the single market. So it's to ensure free movement of goods, free movement of services, free movement of capital, and free movement of labour. So the UK negotiating position is we're pretty keen on the first 2, we're slightly less keen on the last one. The customs union is a aspect of one of those. It's an aspect of the free movement of goods. So that's the area within Europe within which internally there are no customs barriers, but externally there is a uniformity of customs barriers vis-à-vis the rest of the world. Clearly, if you are in the EU, you have the benefit of the single market and the customs union. If you are outside, you don't. So you need to find a solution, and the various permutations and varieties of solution are the next 4 bullets there. So the first 2 are bespoke they're the off-the-shelf solutions. So you have the European Free Trade Association, EFTA, and that is what Iceland, Norway, Switzerland, and Liechtenstein are currently a part of. And those countries, through either the mechanism of being party to the European Economic Area Agreement, the EEA, or in the case of Switzerland, its own bespoke bilateral trade agreement, have varying degrees of participation in the single market and the customs union. So the negotiations at the minute are around those sort of formulations to see where the UK might end up in one of those models. If the negotiations go terribly badly and we agree nothing, then you're left with World Trade Organization rules. And to illustrate a little bit of the complexity around that, that's a table which gives you some of the different permutations across the top, with full EU membership on the right-hand side of the slide, and no deal on the far end of the slide. And then as you go across, there's the varying degrees of the permutations in between. So full EEA membership is the closest to full membership. Then there's the Swiss model. Then you get the customs union with Turkey. Then you get the free trade agreement model with Canada, and then you get the hard Brexit right at the end. And I think the current negotiating position probably puts the UK somewhere between sort of EEA and EFTA minus and Canada plus. So it's somewhere in the middle of that table is where the negotiations seem to be coalescing. In terms of where we actually are now, so the focus is on what's called the withdrawal agreement, and that is really focused on that transition period and getting that agreed, so that effectively the status quo is maintained until the end of 2020, which gives everybody certainty that the same rules apply for a longer period. So we're not talking about March next year, we're talking about December 2020, and that hopefully gives people the time and the space to negotiate something much broader and long-term in the future. And the key point for the UK is the 5th bullet point down, which is whilst it will still be party to the status quo and EU rules, and it will no longer be a decision maker in the formulation of those rules, it's free to start negotiating free trade agreements with third-party countries in its own right. What might stop the agreement? As we said, the first 90% of any negotiation is the EU bit, and this is some of the knottier problems with the remaining 10%. So the first and the third problems are what we call the sort of having your cake and eat it problems. Because the UK would clearly very much like to have the benefits of the customs union, but it would also like to negotiate its own free trade agreements in the same way, which clearly is a negotiating position, is something that the European Union is slightly less in favour of. I think our Foreign Secretary was slightly hopeful. I think he said to the Italian relevant Italian government minister that it made sense to agree a customs union position with the UK, because if they didn't, then the Italians would sell a lot less Prosecco. And the Italian minister pointed out that he may sell less Prosecco to one country, but Boris may sell a lot less to 27 countries. So it was not the best negotiating start. And the second one there is probably the most difficult, in that it's how Northern Ireland is dealt with, which goes back in part to what we were saying as to where the balance of power was. So it was a key aspect of the peace process in Northern Ireland in the late 90s and the Good Friday Agreement that there would be no border between the north of Ireland and the south of Ireland. And of course, when you're part of one customs union, that is easy to achieve. If, however, the UK, including the north of Ireland, leaves the EU, it will no longer have the benefit of the customs union, which by definition will mean some sort of customs barrier between the north and the south of Ireland. That is a position which is unacceptable to the south of Ireland and therefore to the EU, and they say endangers the peace process. And therefore the solution being proposed is to have regulatory convergence between the north and the south of Ireland and the hard border down the Irish Sea in terms of the customs barrier, and the divergence would be between Ireland, or the island of Ireland, and the island of Great Britain. However, as we said, the parliamentary arithmetic is such after the last election that the balance of power in the UK Parliament is with the unionist Irish parties, for whom any regulatory divergence with the UK is unacceptable because it's, to their mind, weakens the union between Northern Ireland and the rest of the United Kingdom. So there are two pretty divergent positions there, and there's not an obvious compromise. I think the compromise that the EU and the UK government were hoping would work was that red line down the sea, and any customs barrier would be there, but at the minute there's no obvious solution to that one. The next slide is probably what we call it's the economy stupid slide, in that ultimately the success of Brexit will probably be around really what happens in the wider economy. So if things are going well at a macro level, then actually, once a lot of the detail is ironed out, which I'm sure it will be, then Brexit will be seen as a success. But if we're in a period of economic difficulty on a more global scale, then no doubt the blame will be attached to Brexit. And I think a key part of that across Europe, not just in the UK, is how corporate tax rates will be dealt with. And clearly, I think over time there will be a sort of a race to the bottom to try and get as low as you can. And the UK is sort of an early runner in that race. I think, and the problem what Ireland has, which is clearly got the lowest tax rates, is that the rest of the European Union see the Irish rates as a bit of an unfair advantage, and are encouraging Ireland to raise their rates. And so finally, is there regret? If we were to vote now, would it change? And the two lines have reversed, so there's a bit more regret than a bit more thinking it's right, but not in any material sense. It's very marginal. And then will there be another referendum? No appetite for that discerned. The position a year ago is effectively the same, and it's about just over a third of the electorate think we should have another referendum. So I think the political environment is such that without a significant change in public opinion, there will not be a second referendum, and Brexit will be happening. Which leads me to pass over to James to deal with some of that.
Yes.
Thank you, Dan. Well, an interesting presentation. I'm sure the parallels between voting patterns in the U.S. and the U.K. and the demographics between the U.S. population, UK population are not lost on anybody in this room. So I'll leave it at that. Our second speaker today is James Creighton. James leads the commercial contracts group at Walker Morris and specializes in complex contractual arrangements, often in a supply chain environment. Prior to joining Walker Morris in 2014, James spent over a decade practicing in the commercial law group at the international law firm of DLA Piper. I'm sure you're all familiar with that. James' practice includes both locally based UK clients and a wide range of international businesses. He has many years of experience advising US companies. James studied philosophy, get this, philosophy at Cambridge, so he's a big shot too. Receiving both a Bachelor of Arts degree and a Master's of Arts degree from Cambridge, and subsequently attended law school at the College of Law in York. James.
Thank you. I'm not a big shot.
To us.
Medium, at best. I'm going to pick up some of the general themes that Dan's spoken about and try and get into some more specifics, and particularly try and have a look at some of the potential outcomes for Brexit and how they may impact on business, and then focus in on some specifics around supply chain. And I'm going to start with a caveat that really just reinforces what Dan was saying. This is all subject to lots of politics, and politics and uncertainty driven from politics is not good for business. It's not good for supply chain planning. So theoretically, everything I'm about to say, and probably that Nick is about to say, is subject to change. So take it with a pinch of salt. But we're going to try and tease out some of the more certain elements. When I was thinking about how to couch this caveat, I came across an article actually last week in the Financial Times where a very well-informed columnist relayed the conversations he'd been having with politicians and policymakers in the UK, and just rehearsed some of the different responses he got on how likely it is that Brexit will happen. The first person he spoke to said that on his analysis of the parliamentary arithmetic and the themes Dan was talking about with the influence of the DUP and the hardliners on both Remain and Leave, he said that there's no version of Brexit that can get a parliamentary majority, so that Brexit won't happen. Nothing will get through the House of Commons. But similarly, well-informed people with exactly the same facts take a totally contradictory view. The head of one of the main think tanks looking at European issues said that the chances of Brexit not happening are now less than 5%. A couple of prominent Remain MPs said that the chances of Brexit being stopped were between 20 and 40%. So that gives you an idea of someone sort of almost certain that it's not going to happen, to people with minuscule statistical anomalies, really, in their view of stopping Brexit. And the column brought forward a quite amusing little anecdote that I think is worth repeating here, which is an old joke about a horse trainer, hence the horse, serving a mad Russian Tsar, where the Tsar, by edict, one day says to the horse trainer, "I want you to take my favourite horse and teach it to speak within a year." And the horse trainer immediately said, "Of course, yes." And the threat, if he didn't make the horse speak, was execution. So the horse trainer's friend said to him, "Why on earth did you agree to that? You're going to be executed. There's no way that you can make the horse talk." And the horse trainer said, "Many things can happen in a year. Yeah. The Tsar may die. I may die. The horse may die. Or the horse may talk." So people who are sort of hanging on the idea of remaining in the European Union have got a year to make the horse talk, mate. So a lot of uncertainty, a lot of people still fighting their corners, but time is passing. Dan's taken you through the sort of first part of this in detail. So trying to say sort of where are we now? You can't really see it, but there is a map of Europe behind there. And if you look at where we are now, we probably come somewhere in the middle of Germany, sort of after the March date and before the October date 2018. So we probably fall somewhere around Hanover or Wolfsburg, if you know your sort of German geography. I thought Wolfsburg is probably quite a good place to pick, really, because that's the home of Volkswagen, and a big argument of Brexiteers, as Stan said about the Prosecco, is that we'll get a great deal from the EU because they still want to sell us Volkswagens and Audis and all those lovely fancy German cars. So halfway down the track, there's a lot of road left to go. Perhaps in a nice, comfortable Audi, perhaps in a more modest British car. there is still a decent amount of timeline to get through there, and I'm going to try and sort of walk through what we know in terms of what's coming down the track, what's been agreed, and where we might be heading. So starting on a positive, March, significant progress. The picture there is of David Davis on the left and Michel Barnier on the right, the EU negotiator, standing in front of a lovely, multicoloured, mainly green document of all the areas that have been agreed so far. And what they're standing in front of is the document that's been agreed at political level for a withdrawal agreement. The green areas, the green paragraphs are sections where the EU and the UK have agreed in principle to what the outcome of the exit arrangements should look like. So encouragingly, there is a lot of green on there, but you will see there are a few areas in yellow, and there are a few more areas actually in white with no colour highlight, and that's where there hasn't actually yet been an agreement. And that includes minor things like the Irish border, minor things like what's going to happen to the Euratom, which is the European Atomic Energy Agency, little details like that. But headlines, good headlines. The main one is that the transition period has been agreed, and that will run from the end of March 2019 through to the close of 2020. So that should give us some certainty, and that gives business an extra period of time to engage in planning. Really, it's an acknowledgement that the mechanic of Article 50 for leaving the European Union was never really intended to be exercised, because it provided for just a 2-year period to do an incredibly complex negotiation. So the can has been kicked. The can has been kicked in principle. That agreement, the withdrawal agreement, does still need ratification by the UK Parliament and by both the EU Commission and the European Parliament. It doesn't need national agreement, which is a good thing. If you look at the European Union's history of agreeing international treaties, the example everyone cites is the free trade agreement with Canada, which took 7 years to agree and was held up at the very last minute by the subnational Walloon Assembly in Belgium, who had a problem with it and managed to hold the whole thing up for the continent of 600 million people to get some last-minute concessions. So we don't have to go through that level, but it does need ratification. What does that transition period mean? It means that there is that additional 2-year period, just under 2-year period, where the same rules apply, where British companies continue to benefit from the arrangements that are currently in place with the European Union. It gives time and space for the negotiations as to what comes next. And really, from a British perspective, those are twofold. There is a very important negotiation with the EU27 to say, look, what is our relationship going to look like going forward? How are we going to have our cake and eat it and retain access without the things we don't like? But the other element of the period for negotiation is Britain's avowed intent to become more outward-facing, to pick up more relations, better trade deals with the rest of the world. The withdrawal agreement allows Britain to initiate those discussions, to put in place in principle agreements with third countries, so that the terms of those trading agreements can come into play on the day the transition period ends. So there is the time and space, in theory, for a sort of a cliff edge to be avoided. The other good thing to happen in that week after the withdrawal agreement was that the European Council published its guidelines on what they think the EU-UK future trading agreement should look like. And again, there are quite a lot of positives in here. The headline is that the EU is willing to work towards a free trade agreement with the UK, but that can't come into force and won't be finalised until the UK leaves the EU. It shouldn't really be a surprise, because if you look at the EU, it has agreed free trade agreements with countries around the world, and is probably one of the most vociferous defenders of the World Trade Organization rules and agreeing bilaterals at the moment anywhere. So, but it's good that that has now been set out as a principle. What the EU was very clear in saying is that what won't be on offer to the UK is the same terms as it gets as a member of the EU. So if you look back at Dan's checkerboard table, yeah, the left-hand column with all the greens, that's not on the table. That is not available. That level of access. There are going to be some barriers. What they are, where that line sits, is for negotiation. The principles are again quite encouraging in areas. So the EU's aim is that trade in goods should continue with zero tariffs, and that should cover all sectors without quotas, without tariffs. So that's a positive. There's an avowed statement towards custom cooperation, which again is encouraging. Trade in services, the EU has said that the UK will continue to have access for services, but they'll be under host state rules. And clearly, as the UK is no longer a member of the EU, it will no longer be involved in the discussions around and setting those rules. But the principle of access is there, and there are provisions on the free movement of people, which have been included as well, which I think Nick will talk a bit more about. But then there's also a question of what is not covered. Passporting. The financial services industry is obviously a huge one for the UK. That's not covered in the agreement. Nick's going to give you some more detail about passporting. And importantly, as Dan has already said, there is no mechanism for an extension of the transition period in the EU principles at all, and that sort of blows into macro level the political problems in the UK with the DUP, that if the negotiations do need an extension, it will need the agreement of the EU 27, so all 27 countries. So we're back to Wallonia. We're back to small interests becoming very big issues in the negotiations, and there are plenty of those that you can see. There's obviously the Irish one is a colossal one, but there's also things like the Spanish have taken a very hard line on Gibraltar. They're not comfortable with Gibraltar being included, so the Spanish could potentially use that as an opportunity to extract some concessions. Gibraltar, by the way, did vote in the referendum and voted something like 99% to stay within the EU because if mainland Great Britain is in trouble as we leave the EU, Gibraltar is in serious strife. So what effect could this have on business? So good things, the market access until 2021, assuming the withdrawal agreement is ratified, is guaranteed. So there is time to run on current status. Obviously, the passporting issue, increased trade barriers. So this is the point that the EU has said there will be trade barriers. It's a question of how severe and how significant they are, but the current frictionless trade will not continue post-exit. Currency fluctuations. This is a strange one because it's not really a Brexit-specific point. Currencies can move for lots of reasons, but certainly we have seen the most immediate effect immediately in the aftermath of the referendum was a huge slide in the value of sterling. It lost something like 20%. We think that as the negotiations continue and as things are agreed or are not agreed, sterling is going to continue reacting. So that is something that certainly we've seen clients where maybe they would have historically been relatively relaxed about contracts with European counterparties where you're dealing across sterling and the euro. Now that is something that's been brought into very sharp focus, and having mechanisms for how you deal with that is something that's the forefront of people's minds. Territorial scope of agreements is another one where this is probably something that people just didn't really give consideration to for many years. And if you're granting a territory and you grant the territory as the EU, you possibly didn't think about what happens if a member state leaves the EU. And now we're talking about a big chunk of the EU, 10%, 65 million people peeling off. And does that will that bit of territory be covered by your agreement that grants the EU as an exclusive territory anymore? Then going forward, the issue of parallel regulatory regimes comes into focus, where at the moment, there isn't absolute regulatory alignment between the UK and the EU, because national governments still have their own rules, but there is a large amount of overlap, and we've seen recently GDPR coming in. Yeah, you've been able to have a fair degree of confidence that actually what's coming in is a European regime. So if you're trading in Europe, you can look at one regulatory regime, and that gives you confidence. Well, that is probably going to diverge going forward for the UK. The EU has talked, and some on the Brexit side of the political spectrum in the UK have talked about the UK becoming the Singapore of Europe and being a very, very low regulatory regime. That obviously spooks the EU side of things. But that just brings in some, the potential of that arising brings in, if you're trading across borders, brings in some issues. And then changes in law. So it may be that actually the UK leaving the EU could trigger in existing agreements the change in law clauses, which may not have been intended to deal with Brexit, but could catch it. And then increasingly, and really from literally the day after the referendum, we've been advising clients on Brexit clauses in their commercial agreements, which obviously on the day after we had to make up what the Brexit clause was going to say. But essentially, most of the Brexit clauses you see day to day will be reminiscent of when you see MAC clauses, the material adverse change clause in a contract, saying, look, if something spectacularly bad happens, then the parties will sit down and renegotiate, potentially leading to termination rights. So they are really now very common in cross-border agreements. There are then a sort of a further raft of considerations that relate to sort of inter-UK trade into the UK from non-EU countries. And there is some positive message here. And I think from a US perspective, this is something where there are potential for benefits. So the UK's ability to negotiate free trade agreements on its own going forward is potentially quite a significant advantage, I think, for the UK-US trading relationship. The UK has historically been a free trade nation and has been a proponent of that kind of approach to international free market economics. However, there have been some public reactions to the idea that we're going to do a grand free trade deal with international partners that sort of run counterbalance to that. So we've had lots of headlines about chlorinated chicken. Apparently, US chicken is sometimes chlorinated, and we don't chlorinate our chicken, and it's a complete affront that we may be required to accept chlorinated chicken under a free trade deal. Lots of talk on the left in the press about a free trade deal being with the US needing to mean that we'll open up the NHS, our public health system, to competition, and that it's going to be the end of the NHS. So there are some quite shrill voices in the media which, for a country with a free trade history, sort of come counter to that. The competitiveness of the UK due to the weak pound is another thing, which clearly that has made everything 20% cheaper, although it's coming back now, which is good for our international partners. On the sort of more realistic side, looking at that's very Boris Johnson and his everything is rosy approach, our Foreign Secretary. There are some really significant time constraints and geographic constraints to the trade deals that the UK can do. So despite having the extension, the transition period, the clock is ticking. And if you look, that example of Canada taking 7 years to do a relatively straightforward free trade deal, the UK has to replace a huge amount of existing relationships, which I'll come on to in a minute. and the clock is ticking. And geography is not in our favour. You know, we're talking about the UK rekindling links with the US, which is more in the neighbourhood, but Australia and New Zealand, we might have very close cultural links with them, but they're a pretty long way away, which tends to hinder trade a little bit. So, key message from this slide is really that the punchline is at the bottom. Now is the time to start looking at how you and your business can be impacted by Brexit. The crux will often come to how much benefit is actually derived from your presence or your trading relationships in the UK. How much is a benefit is derived from the EU membership, and how much relates to actually being in the UK as a market in itself. You know, as I said, the UK is a significant size of market, 65 million people. Compare that to the about 10% of the EU, so it's not insignificant. It's a big GDP number, 2.6 trillion, which is, compare that to 17 trillion for the whole of the EU, including the UK. So it's still some sizable numbers, and there are still cultural, language, legal system, time zone, education, all the things that make people come to Britain to do business in the first place. A lot of those remain post exit from the EU. So it's time to do a bit of a back to square one analysis and say, look, why are we in the UK? Why are we trading with the UK? Is it because of the EU membership, or is that just a nice to have? Is it some bonus on top? So that brings us on then to talking a bit more about supply chain specifically. The first point there is just to observe that generally over the last number of decades, supply chains have become more international, more complex, more integrated. So a disruption of the type that Brexit could present is probably more difficult to deal with now than it ever has been before. Some statistics on intermediate goods and services and what they make up of Britain's trade are interesting. So intermediate goods and services are the sort of the bits that go into a finished product rather than the finished product. So we're talking about the part of an engine rather than the complete car, or the fabric rather than the suit. So over 50% of the UK's imports from the EU are intermediate goods that are coming in and then are possibly going out in a finished product. And nearly 70% of the UK's exports to the EU are intermediate goods. So there is a lot of stuff just crossing the borders without any barriers at the moment. That kind of supply chain is clearly going to be sensitive to interruptions. So ultimately, everything should stay the same until at least the end of December 2020. The UK intends to roll over the trade deals that the EU has in place with third countries. That is ambitious to do that in the time period which is on offer, but it's not unreasonable. It could happen with a fair wind. But the two areas we've drawn out there for specific concern for supply chain come into two bundles. One's big, one's not so big. The smaller one is aviation agreements, where for historic rules, aviation agreements are not part of the World Trade Organization rules. So if you don't have a treaty covering your aviation links between countries, there isn't a WTO to fall back onto. So supply chains which are impacted, particularly or which are particularly reliant on air freight, there is probably a bigger chance that if no deal happens, there would be serious disruption than if you're relying on sea freight where you've got world trade. Then the other one is bundled under the catch-all headline there, free trade, and that is the disruption potential of those tariffs and the non-tariff barriers. So if you're bringing products in and out of the UK from the EU, you may in future with tariffs if the zero tariff agreement is not struck, and you almost certainly will be dealing with some element of customs checks, increased documentation going over the border where you've not been dealing with that in the past. This slide is really the very positive approach, the Panglossian approach of some of the Brexiteers particularly, has revived this old headline that was allegedly in the Times many years ago, which is probably apocryphal, but fog in the Channel, continent cut off, which is the Little Englander approach that actually we'll be all right. It's really the continent that's going to struggle by not having links with the UK rather than the UK having a struggle not being linked with the UK, which is probably a bit tongue-in-cheek, but this gives you an idea of the reality, really, that it is probably Britain's problem to sort rather than the EU's. This is a little out of date now, but it gives you an idea. These are the different territories around the world that the EU has some trade deal in place with or is in negotiations to have one. And you can see that pretty well most territories where you'd want to be trading are covered or are in negotiations to be covered. So the UK has a lot of work to do if it's intending to replace these current arrangements with new arrangements going forward. I think it's only 15% of the UK's current trade is not covered by an EU trading relationship. So 85% of the UK's international trade needs to be rolled over into either the agreement with the EU or agreements with so-called third countries. Just from a practical perspective, even with the extension, that is a lot of work to do. Very, very mundane point, but the UK has not negotiated in its own right for any trade agreements for decades because that has all been done by the EU. So finding a load of trade negotiators who are experienced and confident to do this in a very short space of time with a lot of countries at the same time is quite a practical challenge. Having said that, the UK has commenced discussions with the third countries, as they're called. We're in a third country today, and the feedback that is coming out in the British press is that most third countries have indicated that they are willing to roll over those agreements, and that it could actually be done in a relatively simple manner by an exchange of letters, a memorandum of understanding to just say, when the UK ceases to be a member of the EU, it will have a new trade relationship on exactly the same terms with the third country, with the US or China or whatever. However, that relies on countries taking a very simple and positive approach to negotiations, and there have been already some suggestions that some countries will seek to use this as an opportunity to get a better deal, effectively, that they thought that the deal that the EU got was a bit too good, and that now is an opportunity with the UK on the back foot with time constraints and a much smaller market to get a better deal. This language that is probably redolent to you from your own administrations talk about trade. South Korea and Chile have been mentioned as two countries where they are not minded to just roll over and give the UK the same terms as the second biggest trading bloc in the world. So we will have to wait and see on that. What can we do now? What can you do now, looking at the business's supply chain, looking at what we know today? And it's really the point, again, is about audit. It's about undertaking the analysis of your supply chain today, even if you don't know exactly what the changes that are going to be coming down the line will be. It's better, we think, to look, understand what your potential vulnerabilities are, and to have that ready for when certainty emerges, when the fog clears, rather than let it creep up on you. The other point is that analysis is not something that can be really taken off the shelf, because there isn't likely to be a one-size-fits-all answer to Brexit. There was a really interesting analysis that Bain did last year, which really draws out, I think, some of the variabilities between industries, between sectors, even between players in the same industry. Brilliant example of they took the sugar industry, where two large sugar producers in the UK. One is Associated British Foods, large producer with operations in the UK and Spain, and it uses sugar beet. Now, a hard Brexit would be terrible news for Associated British Foods, because it would be very, very badly impacted by World Trade Organization tariffs on sugar beet, as opposed to the EU tariffs. Their main competitor is a business called Tate & Lyle. Tate & Lyle, very large producer of sugar. Their UK operations largely rely on sugar cane imported from Brazil. Hard Brexit would be fantastic news for them, because the WTO tariffs on sugar cane are very low compared to the protectionist tariffs that the EU imposes. So, two businesses which on the face of it do the same thing in the same industry, but would have radically different outcomes compared, depending on the deal that is finally struck. So what are the main changes on expiry of the transition period? Clustered into three broad groups. There's tariffs, which we've spoken about. That's the trade element. There's VAT, where at the moment, if you are operating in the UK and you are taking imports from the European Union, you're not paying VAT at the border. You're paying VAT is the sales tax. You're paying VAT when you sell the product. That will change. You will pay VAT on import from the EU, unless you can strike a deal with the tax authorities in the UK. It might be possible, but it might be complicated. So that's, if you're looking at a supply chain, that has got a potential big cash flow impact. So you're suddenly paying a tax on goods that then sit in a warehouse or sit in your processes for a period of time, rather than only paying the tax when you get the revenue in for it. And then customs checks. This is the really big one, I think. And as Dan went through, it is very hard to see how this will happen without friction. Ireland is a really great example. The Irish border, there are implacably opposed sides of the argument, which will mean that any customs checks would be incredibly controversial, but practically they would be very difficult. As it stands, between the EU and Eastern Europe, so EU and non-EU countries, there are currently 137 border crossings. Between the Republic of Ireland and Northern Ireland, there are 208. The border runs along 11 roads, along the middle of the road, and meets on 3 bridges and dissects 2 ferry crossings. So if you have to put a physical infrastructure in place to do customs checks on that kind of border, I mean, it's just, the mind boggles, really. That's one specific issue in Ireland, but the main avenue for trade in the UK coming in from the EU are the Channel ports, mainly Dover. Before the EU, a lorry travelling from Milan to London had to have 88 pieces of paper to make that journey happen. That's been replaced by 1 document under the EU regime. So no one's saying we're going to go back to 88 documents, but even if it's 5, 10 documents, that is a significant regulatory burden. The answer to this is proposed by the UK is sort of twofold. The UK's government put forward two solutions. One of which technological solutions. They say you don't need border infrastructure if we have software and technology, automatic number plate recognition, that kind of thing at the border to let trucks come through without actually having to stop for inspection. That doesn't happen anywhere in the world at the moment. It's the EU has said it's magical thinking to suggest that could happen at the UK border. But the UK government persists that this is something that will be possible in 2 years. And then the other is a sort of more complicated proposal around the UK checking goods on behalf of the EU as they come in through the EU border. Again, this is something that the EU has been quite dismissive of and has said is not really practical. Their main concern is that if goods coming in at the UK border are tariffed for UK market use, but then somehow find their way into the EU market without paying the EU tariff, the UK effectively becomes a backdoor to avoid the EU's unitary external tariff. So strong resistance from the EU on these two supposed solutions, but the UK government persists that they will be able to pull one or the other of them off. So finally, and I'm conscious I'm running well over here, some practical considerations for supply chain. Really important to map it and understand and see where things are coming to and from. Looking both at your suppliers and your suppliers' suppliers, because we spoke about the interdependent supply chain. If your suppliers are not doing the planning themselves with their supply chain, then you might come across with that. And also customers. Are your customers going to be impacted by Brexit? Because if demand suddenly drops off, then maybe you need to be recalibrating your supply chain in the first place. Trying to identify alternative supply routes might include looking at ports away from the channel ports. So the UK has a range of ports that are more used to international trade. Most US trade, for example, comes in through Liverpool or through Felixstowe, which are already have the physical infrastructure to deal with more customs checks. So is it possible to use those as routes to Europe? Cash flow we've talked about from a VAT perspective. There may also be a cash flow impact from some contingency planning, where you may say, actually, if there's going to be a particular crunch around the deadline day when the transition period ends, you might want to have an increased stock holding to deal with any bottlenecks at the ports. So that's clearly going to have an impact on cash flow. And then the final practical point I'll make is something which really had not got any publicity in the UK at all until relatively recently, which is this authorised economic operator status, which is a process whereby effectively you become a trusted trader and you go through checks and audit processes to get this authorisation. And that then allows you to have fewer customs checks, to have fewer regulatory burdens at the border. It's something that exists now, but has had spectacularly poor uptake in the UK. I think that's it. The UK, there are 624 approved authorised economic operators, whereas in Germany there are 6,000, the Netherlands 1,500, France 1,600. So it's not really happened in the UK, but it is possible to do it now, and there is a lag time. It takes apparently about 6 or so months to prepare, and then there's a 6-month application process. But if you're concerned about the impact of bottlenecks and customs checks at the borders, and your business is reliant on it, it's something that you can actually put in chain now, which would be a practical advantage when those customs checks come in some form in 2021. So that's a quick canter through some of the sort of practical aspects of what we know now and how it might impact on your supply chain. I will finish as I started with a massive caveat. And again, Dan suggested you would hear this a number of times today. But this is the Donald Tusk, President of the European Parliament. Nothing is agreed until everything is agreed. And at the moment, although we've got agreement in principle on a lot of things, that final 10% that Dan spoke about is still looming. Mm-hmm. Thank you.
Thank you, James. Terrific presentation. I like your characterization of kicking the can down the road, because we're awfully good at that too, aren't we? But I wonder what happens if not everything is agreed, as your last slide says, and the end of 2020 arrives and doesn't sound pretty. In any event, so our third presenter today is Nick Lees. Nick is a partner in the commercial dispute resolution team at Walker Morris. Nick joined Walker Morris in 2011 after working at the London law firm of Ashers and the international law firm of DLA Piper. So obviously a big shot as well. Nick's litigation practice covers a broad spectrum of commercial and contractual disputes, including disputes arising from defaults by counterparties and suppliers and contentious issues arising from corporate transactions. Nick conducts litigation in the English courts as well as practicing arbitration and mediation. He has recently represented UK businesses of Caterpillar Inc. in the substantial litigation with their former distributors in Nigeria and Turkey. Nick holds a bachelor's of arts degree in English literature from Durham University before attending law school at the University of Law in London. Nick.
Thanks, Rich. Good morning. I'm the final leg, so we're almost there. I'm going to speak for about 15 minutes, and we're going to cover 6 topics, so a fairly quick canter through, but just to flag some practical points. We're going to look, first of all, at data, secondly, at IP protection, thirdly, at employee immigration, and then very quickly we'll have a look at issues arising in 3 specific sectors, so food and drink, financial services, and medical technology. So data. As part of the single market, we've got lots and lots of transfers of data passing between the UK and the EU, but we're coming out of the single market. So what are the implications going to be for dealing with all of that data? There are some issues to think about and monitor, which we'll share, but we're optimistic that there'll continue to be a stable regime of data flowing between the UK and the EU countries after Brexit. James has mentioned the European General Data Protection Regulation. That is coming into force in a couple of weeks' time. There was a question mark about whether Brexit may impact on that. It is coming into force, and it will remain part of UK law after Brexit. So at the point of Brexit, we're starting from a point of completely unprecedented alignment between what will be UK data protection law and EU data protection law. They're going to be one and the same. So what is it we need to monitor then? Well, GDPR, it prohibits the transfer of personal data outside of the EU unless adequate protections are in place. We're no longer going to be part of the EU after Brexit. So the starting point under the law is that data transfers to the UK will be prohibited after Brexit unless adequate protections are in place. So something has to be done, something needs to be done. And we need to monitor that that's dealt with at a state level. And if it's not, then it's going to require action by individual companies. And there are things that companies will be able to do if it's not dealt with at that state level. Now, our view is that it's most unlikely that our UK government is going to decide that the EU is not an adequate jurisdiction. So the focus is on ensuring that there'll be no restriction of data flowing from the EU into the UK after Brexit. And the options, there might be a direct agreement treaty. Alternatively, there is something called an adequacy decision that can be obtained from the European Commission. That's granted when the European Commission satisfied that the level of data protection is equivalent in the third country, which will be. So Switzerland has one of these already. New Zealand has one. Japan has applied for one. South Korea has applied for one, so it's a well-trodden path. Did take New Zealand 4 years to sort out its adequacy decision, but then I'd come back to the point made at the beginning that we start from this point of unprecedented alignment between our data protection laws and the EU data protection laws. So those are at state level. If an agreement's not reached at state level, so we don't get a direct agreement or an adequacy decision from the Commission, then individual companies can do things. And these are things that are familiar already to companies doing business and to those advising them on data protection laws. There are model clauses, so-called model clauses. These are standard clauses, contract clauses, which are approved by the European Commission. And when they're signed between an EU data exporter and a non-EU data importer, then you're allowed to transfer the data can flow. And these have been popular with companies who are already transferring data outside of the EU. As I say, they're well understood, well used. They're not the only option. Binding corporate rules are another option. These are for multinational companies. They can transfer personal data from within the EU
to group companies outside of the EU. They can take a little while to sort out these binding corporate rules, and there can be a bit of cost involved. So model clauses have been popular, but they are another option, binding corporate rules. And finally, codes of conduct. These are a new feature coming in with GDPR in a couple of weeks. And they enable representative bodies and trade associations to propose their own rules to the supervising authorities in the EU for approval. And once the European Commission has approved the code, then data transfers can take place in accordance with that approved code, so long as there's an enforceable commitment given from the non-EU company to apply the code that's been approved by the Commission. So just briefly, just a word on whether Brexit will present an opportunity for data protection reform in the UK, which might free up the flow of data between the UK and the US. Now, because of this requirement for adequate protection that I've spoken about, which has to be dealt with, in order for us to maintain the status quo with data flowing between UK and EU, we don't think, unfortunately, depending on your view on these things, that the UK is going to be willing to stray very far from the EU's position on data transfer with the US. And that's because it's going to be easier to maintain the status quo, to follow the status quo as it is at the moment. So, just the final word before we move to intellectual property position on data. There's no need, we don't think, to put in place contingencies right now. It's a monitoring, because we think it will be dealt with at state level. But if not, then there are things that can be done, as we've discussed, that lawyers can help with. And the practical point for businesses right now might be to just continue or to consider mapping the flow of data between UK and EU countries, so you know which arrangements will need to be dealt with by your lawyers if it's not dealt with by an overarching state agreement. So IP protection, something to mention to you. It's worth thinking about pan-European rights, which protect intellectual property in the form of EU trademarks and registered community designs. And these have been popular because they're cost-effective to obtain, and they save you doing a filing in each EU country. You just do one filing and you get the protections. And there's been a question mark about whether these rights will continue to give you protection in the UK after Brexit. Right, so that's a big deal if these are valuable rights to your business. And the advice that's being given by the IP legal community is to audit your portfolio and identify these EU trademarks, these registered design rights, and to think about making new additional registrations, domestic registrations at the UK Intellectual Property Registry. That involves some costs, some administration. Flip side of that, there was a concern raised that if you go about seeking these fresh domestic registrations in the UK, then there was some potential for putting your marks at risk if for some reason the UK Intellectual Property Office decided to refuse the registration. You're going to have an inconsistent position. But there's good news. We come with good news to share. There's been an important development in March 2018 in the draft withdrawal agreement, which has been spoken about already. Now, as has been said, that's not signed yet, but these are firm commitments that won't change. After the transition period comes to an end, the end of 2020, owners of these current EU trademarks and protected designs will, without any re-examination by our own domestic IP office, become holders of comparable and enforceable rights in the UK. Secondly, where an application is pending in Europe on the final day of the transition period, then the applicant will have 9 months grace to make a domestic filing in the UK. So this is good news. The issue some people have with it is that the detail, the legal mechanics of how these comparable rights are going to be created and transposed, that hasn't been published yet. And of course, lawyers, we like detail. We like to see the detailed mechanics to advise our clients. So if you are a business where trademarks or registered designs are important assets, there is a decision to be made for contingency planning as to whether you press on and make those fresh domestic registrations anyway, or if you want to sort of wait and see and monitor carefully for the detail which should be with us, well, it will be with us by October of this year. So, employee immigration. This was, as has been mentioned, this is one of the big political issues leading to Brexit. Our UK government has said it's not possible to control overall immigration coming into the UK, where there's unlimited free movement of people from the UK to the EU. And the immigration policy from EU workers coming to the UK and vice versa that's going to follow after Brexit remains unclear at the moment. It's going to be really important for us because our UK economy has a lot of migrant workers in certain sectors. So in hospitality, food, construction, healthcare, the EU workforce has been important. Now, when I wrote this talk, and we were talking about it in the office, the UK government was, it was very clear that free movement from the EU was definitely coming to an end. And Dan picked up a newspaper yesterday morning on his tablet. And lo and behold, it's reported in the news yesterday that our government is working on an offer to the EU, which might look very similar to free movement, but with an emergency brake to enable us to restrict migration when it's in our national interest to do so. So this just goes to show that it is still a moving feast. You know, the politics are very important and things do change. Now, the position is that EU nationals who've been continuously living and working in the UK for 5 years, this is the position in law, they will have acquired permanent residence, allowing them to remain indefinitely, you know, no matter what might come after. Done 5 years, then you can stay, you can work, you can live. So contingency planning steps that were being suggested were, you know, people should look at their workforce, you know, make sure, help their workers to make sure that where they've got the 5 years, they've got the paperwork in order so they can stay. Maybe have that discussion with your supply chain if your supply chain relies very heavily on migrant labour. So we act for a drinks company that has needs lots of blueberries, blackberries to make its drinks. You know, and there's a lot of migrant workers picking the blackberries that go into the soft drink. Again, there's been good positive news in the draft withdrawal agreement. Good positive news on immigration. So during the transition period, which will run to the end of 2020, UK and EU citizens can continue to move freely around the EU and the UK. And afterwards, so long as they're there, they can stay and work in the UK or the EU to get those 5 years which are necessary to apply for permanent residency where you can continue working. So that was seen as a victory actually in the negotiations for the EU. So a new sort of new point following on from that is to, you know, to consider in the business, in your business, getting your EU citizens to where they need to be from the UK or vice versa before the end of the transition period so they can then stay and get those 5 years. So, you know, it's about thinking about moving people before we get to the 31st of December 2020. And again, these are, you know, these measures are to be welcome. It's good news. Brings some reassurance over the medium term to individual workers, which is important, and also to companies who rely on an EU workforce to be competitive. Just very briefly on Ireland, the island of Ireland has been a long shared history between UK and Ireland. There's a common travel area which encompasses the UK and Ireland. And that allows people to travel and work freely within the two countries. And that predates the EU by a long time. That arrangement's been in place since 1923. And that's continuing. Both the UK and the Irish government's very clear that arrangement is going to continue, notwithstanding Brexit. There'll be a few wrinkles to work out, which will be depending on what the policy is on immigration. You know, people coming through the back door, so getting Eastern European nationals coming in, getting residency in Ireland, then hopping over to Britain. That needs to be worked out, all that detail. But that's a work in progress. And then very briefly on employment laws. Our employment laws after Brexit, our government's made it clear that it's not going to weaken employment protection in the UK post-Brexit. So hiring and firing is not going to get any easier. But, you know, it still remains, we're still more liberal in our employment laws than many other parts of the EU. And then 2P was a little throw in there just for the corporate lawyers who were in the room. This was something I was speaking to Dan about when we were preparing the talk, which I understand this can be a headache for US transactional lawyers, this concept of when buy part of an undertaking, the workforce has to go with it. But this is going to be remaining for the medium term at least, so those headaches continue for you guys. Food and agriculture, so just moving on to the sectors now. James has covered, there's going to be opportunities if trade barriers come up. There's going to be opportunities for doing business, and food and drink it's absolutely fundamental to a developed Western economy that we've got, that we don't have disruption to our food supplies. And at the moment, food supply is very heavily integrated across the UK and the EU. So 70% of UK food and non-alcoholic drinks exports go out to the EU, and that's non-alcoholic. So I think the Scotch whisky, lots of it comes to the US and other places, so it slightly skews that statistic. But we in the UK, the EU imports to us are larger than our exports out to the EU. So our exports, about £9 billion worth of food and drink goes out, and about 24.6 billion comes back in. And the EU's been quite protectionist with its food and drink tariffs that are applied to third countries. So, if trade barriers do go up, then there's a big market of 65 million people that are going to need to be fed and watered, so that will present opportunity. So just a couple of interesting statistics. So 60% of the wine that we drink in the UK comes from France, Italy and Spain, just from those three countries. There's lots of other good wine-producing countries like the US, Australia. 26% of our poultry meat comes from the EU at the moment. Well, I like poultry meat, so I'd rather be having chlorinated chicken than no chicken at all. So there is going to be opportunities. Regulatory considerations. There's a list there. I'm just going to sort of pick off two, given the time, just to sort of illustrate the point. Genetically modified foods and animal feeds. You need EU authorization for cultivating and selling on the EU market genetically modified food and animal feed. And food business operators have to be established in the EU to get that authorization. So as matters stand at the moment, absent any agreement, being established as a GM producer in the UK after Brexit means that we won't be able to comply with the establishment criteria and won't be able to sell our GM products into the EU market. So contingency plans are required for businesses in the GM space. The next one I'll pick off is food of animal origin. Animal products move freely around the EU at present between the UK and the EU. After Brexit, it's no longer going to be possible for UK animal products to move to the EU freely. Certain conditions, regulatory conditions, are going to have to be met, which UK operators don't have to deal with at the moment. So these third country regulations are third countries deal with, but not UK businesses selling animal food products into the EU. So the establishment from which the food comes, it has to be approved by the European Commission when you're a third country. And the products themselves must be certified that they satisfy certain EU hygiene requirements. And these things they're controlled by, back to the point James was talking about, by mandatory border checks, checking the paperwork, and then on occasion physically checking the consignment. So I think, and please feel free, any of you, to kind of, if you want to know more about the things I haven't spoken about, but the headline is that for some of these things, there's going to be a layer of regulatory burden added, but that can be managed by making the investment in the people and the systems to deal with new regulation. But then, for GM, that's a tougher one, because as we stand at the moment, there's this establishment criteria, which means that, GM businesses are going to have to look for establishment in the EU, or they're going to have to look for new markets to sell their products into, because they won't be able to sell them into the EU after Brexit. So, okay, financial services. This is one of the most complex areas of Brexit, and it's an area where there's still a lot of uncertainty. So after Brexit, banks, insurance companies, and asset managers won't have the same freedoms that they do at the moment. A key aspect of EU financial services law is that firms authorised to carry on certain activities in one member state can carry on those activities in another member state. This is called passporting, this concept. And you can do it by, you can provide the service cross-border, or you could set up a branch in another country. And that's, there's been a lot of integration of financial services throughout Europe on the basis of a set of permissions from your home regulator. You can then passport, do business in the other EU countries. The point of this slide is there was no overarching simple passporting law. The principle is applied in different sectors by various different complex legislation, depending on what it is you do in financial services. But the headline for a financial services business is that these passporting rights are going to be lost unless something is done. So firms authorised in the UK by our own financial regulators won't be able to provide their services and distribute their products in Europe after Brexit, and the same will apply to European firms. There is a concept of equivalence, which allows firms which are established in third countries to operate in the EU, where the legal and regulatory requirements of the home market are equivalent. But there are some limitations on that, so it's not a complete answer. It's not going to be a complete answer. The process is very complicated, depending on the sector you're in, those different laws we just flagged on the slide. And there's also been some talk that the right to grant equivalence is reserved. It's a reserved right to the European Commission. It's not an automatic right. So, there is some risk of that being used as a political tool, depending on where the negotiations go. So equivalence is there. People can advise you on that, but it's not a complete answer. We've got a bit more time now. We've spoken about the transition period, and we've spoken about how that kind of kicks the can down the road a bit, but financial firms are carrying out contingency work and restructuring work at the moment. They've been looking at their regulatory frameworks, their governance frameworks, their operational frameworks, and they've been working out, what's going to be required to set up a replicative business in different parts of the EU, or maybe to use other entities already in their group structure to trade through. So this is really a sector where there is risk in not acting now. This is one of the sectors where it's important to do contingency planning because of the sheer complexity around establishing a financial services firm and getting authorised if you do want to get yourself established in a different country. So some tough decisions to be made about making that investment, or maybe just coming out of those markets and focusing on the domestic market. And finally, just to wrap this up, just a final word on medical technology. We just want to flag one thing to you, if you're in the medical devices business, which is that manufacturers of medical devices which are imported into the EU from third countries have to appoint an authorised representative under EU law, and this authorised representative has to be established in the EU. So that rule applies to all non-EU manufacturers of medical technology devices, and you have to print the authorised representative's details on your product packaging. And the European authorities can call on the authorised representative for vigilance, and the authorised representative has a duty to respond and produce a technical file on the product. And these authorised representatives, again, it's an establishment point, they have to be located in a European Union member state, which we're not going to be after Brexit. And it's estimated that around 50% of people in the authorised representative business for medical devices are based in the UK. So after Brexit, unless they do something, they're going to be unable to fulfil that role. So the contingency planning step is to talk to them now to understand what they're doing, to address that situation, have that dialogue sooner rather than later. So that wraps up my section. And I think the common theme, in what I've been talking about is in that most cases, contingency planning is looking at the possibility of having to adapt some of your UK operations to deal with new regulation. And that's going to need some investment and some management. But then, for some other things like GM, financial services, maybe more radical planning is going to be required unless, there are developments at the political level. Because the situation might be that, you need to get established in Europe to carry on getting access to the EU market. And then there is a piece of work to do, about deciding where best to go. And I think, we're all optimistic on this panel. There's a real common interest for the EU and the UK to make things work. Some of these things I've spoken about where there's still difficulty, there must be a political will to make things work. And some of the things that we've flagged to you, they're not the final word. The negotiations continue. And, if there's anything in particular that I've mentioned that has kind of raised interest, raised an alarm bell, that you want to keep monitoring, then we're very happy to keep in touch. You've got our details on the slide here. So if you want to keep tabs on anything, then do drop us a line, and we're happy to keep talking to you as the story unfolds on some of those things. Thank you very much.
Thank you, Nick. Terrific presentation by all three of our panelists. We have a few minutes, I think, for questions and answers. So if you've been thinking of a question you'd like to ask, now would be a good time. Yes, sir. Go right ahead.
Question that relates to passporting rights. Currently, a lot of companies have, let's say, legal entities in various jurisdictions, and you might have employees that are considered dual officers. So they're authorized to act on behalf of one entity, a second entity, a third entity. You think there's going to be any tolerance for that in a post-integration or post-Brexit environment where you would still be able to use dual officer authorities?
So are you in banking or which sector?
Oh, yeah, this is banking, so financial, the passporting of financial services.
Yeah, okay. So, the answer is, I guess it depends on how the passporting is dealt with. So there are quite close discussions ongoing about how, getting something better than equivalence that's going to, get as close to passporting as we might be. There's a real interest in making sure that the capital keeps to flow freely around the EU. So, I think depending on what's agreed, then that would be an aspect of continuing the very close alignment. But at the moment, unless something's agreed, then not. Actually, just interestingly, on financial services, the government, our UK government's now talking about passing emergency legislation to not to scare me, but to provide temporary permissions on things like that to allow EU firms to continue trading in the UK after Brexit. So a bespoke arrangement to maintain the status quo till the complexity in the financial services arena can be worked out. And the Financial Times reported a couple of days ago that the EU is working on legislative proposals to cover off the same things. And that's because, we can't have a situation where there's another financial shock. We're just kind of 10 years from the last one, in Europe and in the US. So if stuff like that isn't agreed, there needs to be an orderly wind down so people know where they are and can sort of, restructure businesses accordingly. But like I said, we're optimistic. Why would you change those things? They've worked well. So I guess I don't have an immediate answer for you, I'm afraid.
Right.
Any other questions?
Nick, you mentioned this thing about having an EAR for medical device. I assume it's the same thing for any device that required CE certification, electronic devices, everything else. And is there any planned changes as far as the process that a U.S. manufacturer have to go through, which is quite expensive and time consuming? Have you talked at all about the impact of CE certification on the Brexit, how that's going to impact it?
No, that's a great question. No, we haven't touched on that. And, I don't know the immediate answer. I mean, we kind of spoke about medical technology, and I know about the requirement for the authorised representatives in the medical technology sector, but maybe if I can get your details, we can kind of pick up on that, because that's a really interesting one.
I have a client right now, we're going through the CE certification, and our EAR has an office in the Netherlands.
Yeah.
Do not have one in the UK. So what do we do now?
Yeah. No, great.
I'll give you my card afterwards.
Yeah, brilliant.
Any other questions? I have one quick question, and then we'll wrap up. I know that there's been talk in the UK of a change of prime minister, or maybe even the government in general. How would that affect the workings of Brexit going forward for any of you?
I don't think it will massively. Thanks. I think the horse is still not going to talk. Whoever is Prime Minister and Brexit will happen. I think Labour Party policy is more in favour of the more EEA model, so being part of the customs union. So that is the much softer form of Brexit is a much more likely consequence of a Labour government. If it's just a change of Prime Minister, then it will probably be a similar outcome to what it is now. It just may be a little bit more deliverable. I think there's a perception that Theresa May was a Remainer in the referendum, and that perhaps to effectively conclude the negotiations and bring both sides together, you have to be a Brexiteer in order to sort of deliver a harder form of Brexit.
Any other questions? Well, with that, we'll close the seminar. Thank you all for coming. We've got another round of applause for our